Hello everyone, my name is Nkem Violet Ache. I'm a PhD student at Law School, Robert Gordon University, Aberdeen, United Kingdom. The title of my paper presentation is The Impact of Multinational Oil Company Levels of Engagement with Their Human Rights Obligation in Human Rights Litigation in the Niger Delta. The outline of this presentation is as follows. I will first introduce the paper. Then I will talk about the human rights obligations of Shell and the multinational oil company levels of engagement with their human rights obligation and the importance of human rights litigation arising from the Niger Delta. After that, I will discuss my finding and make my concluding remarks. I would like to start by saying that the way multinational oil companies handle issues and complaints varies and can demonstrate the level of engagement with their human rights and environmental obligation. The levels of engagement could be inactive, reactive, active, and proactive level of engagement. The lack of an appropriate level of engagement is the reason for recurring conflicts and incidents of human rights and environmental violation in the Niger Delta, which in turn has led to numerous transnational human rights litigation. Now, the Niger Delta is an oil-rich region in the southern part of Nigeria and have been centered for international controversy over oil and gas pollution. The human rights obligations are policies a company develops or sign onto to indicate what the company intends to do to address its human rights and environmental programs. These obligations cover a wide range of aspects, including transparency and disclosure of evidence that could be required by the plaintiff, security and safety, prevention of oil spill, cleanup of oil spill, and also compensation. So this paper considers Shell as a case study to illustrate the relevance of human rights and environmental obligation. Shell's human rights obligations are contained in several sources, such as its official website, policy and procedural manual, reports, agreement, Shell sustainability reports, code of conduct. For example, one of Shell's human rights obligations is stated as follows. Shell is committed to respecting human rights as set out in the United Nations Universal Declaration of Human Rights and International Labour Organization Declaration on Fundamental Principles and Rights at Work. Let us be very clear about the legal importance of human rights obligation of the multinational oil companies, which is usually taken lightly. For example, Shell filed incorrect information with the US Security and Exchange Commission. As a result of that, they had to settle a fraud case with the SEC in 2004 for overstatement of billions of barrels of proven oil reserves in violation of the Security Exchange Act 1934. So let us summarize the three transnational human rights litigation, starting with Liwa and Shell. In this litigation, the plaintiff sued to hold Shell liable for complicity in the wrongful arrest, detention, and execution of 9 environmental activists by the Nigerian military. And also the issues for determination. There are 2 main issues for determination. The first was whether the court could exercise personal jurisdiction over the defendants, Shell and ICBELLIP, and 2, whether the human rights abuses in the litigation fell within the scope of the authority of the federal court based on the Alien Tort Act. So the Court of Appeal ruled that the US court could exercise both personal jurisdiction and forum non-convenience over the defendants on several grounds, including that the Shell was doing business in New York and the trial would be expensive and inconvenience the plaintiff if held outside the US. So before the trial court, at the eve of the trial court, on June 8, 2009, Shell settled the case out of court and paid about $15.5 million to the victims. In Bodo and Shell litigation, a group of Nigerian farmers and fishermen filed a lawsuit against Shell and ICBELLIP for 2 oil spills in Bodo community. The 2 main issues for determinations are whether the claimants are only entitled to claim compensation in respect of the 2008 spills under the Oil Pipeline Act, and whether ICBELLIP could be held liable for oil spill due to sabotage rather than faulty maintenance under the Nigerian law. The court ruled that there is no liability for oil spill caused by sabotage under the Nigerian law, but that liability could exist due to neglect of the protection of the oil pipeline. So a few months before the trial was set to proceed, based on the evidence produced, Shell settled the litigation out of court with a sum of $55 million. Also in Oguru and Shell, 4 Nigerian farmers and a Dutch NGO filed a claim against the Royal Dutch Shell and the ICBELLIP for failure to exercise due care to prevent the oil spill and also to clean up contaminated sites. And the 2 main issues, I got about 3 main issues for determination. 1, whether the Dutch court could assume jurisdiction over the claims against the Nigerian subsidiary. 2, whether the oil spill had been caused by faulty maintenance or by sabotage, and whether Royal Dutch Shell owes a duty of care to the claimant for harm caused by ICBELLIP. So in most recent decision in January 2021, the court ruled that Royal Dutch Shell owed a duty of care to the claimant and is liable to pay compensation and clean up due to failure to prevent oil spill. And Shell was also ordered to install leak detection of its equipment. So let us explain the different multinational oil company levels of engagement with their human rights obligation. In an inactive level, the company approaches the litigation by being defensive and calculating on how to kill the case. In the reactive level of engagement, the company approaches the litigation by being defensive and calculating on how to minimize the risk if they cannot get away with the allegation. Also, in the active level of engagement, the company approaches the litigation to resolve the dispute. And also the proactive level of engagement, the company approaches the litigation to resolve the dispute and also to contribute to resolving future complaints. An example of the reactive level of engagement is when the company bluntly refuses to disclose evidence, but will do so only if it's unavoidable due to their legal obligation and also pressure from the government and also from their investors. Then a proactive level of engagement is when the company discloses evidence and also puts in place a mechanism to provide evidence in future. So an evaluation of the level of engagement against the 3 litigation shows that there is no evidence that Shell proactively shapes and implements its human rights obligation. In the case of Wiwa and Shell, Shell was inactive in its approach because it was defensive and calculating on how to kill the case. In Bodo and Shell and also Guru and Shell litigation, Shell was initially inactive, but later they were reactive in its approach in order to minimize the risk. And they do this only if it's unavoidable. For example, Shell only accepted to pay compensation and clean up of oil spill when evidence emerged in court during litigation, and they were warned about their faulty maintenance, but they failed to take action. So, aspect of Shell inactive and reactive approach to human rights litigation. Shell was inactive and reactive in its approach in several ways, including lack of transparency, non-disclosure of evidence, poor safety and security, prevention of oil spill, cleanup and compensation for oil spills. So I would like to discuss a few aspects of Shell inactive and reactive approach in engaging with their human rights obligation. Shell used several techniques to postpone the litigation initiated against them. In the case of Wiwa and Shell filed a motion to dismiss the case on the ground of lack of jurisdiction. Also in Oguru and Shell challenged the standing of the individual claimant and also joint claimant, which delayed the case from moving forward. Shell also demonstrated a lack of transparency in the oil spill data provided and also refused to disclose crucial evidential documents. In Oguru and Shell litigation, the judge had to intervene by ordering Shell to bring documents to the court for the analysis by the plaintiff to prove what Shell knew about the condition of the oil pipeline and its internal operational practices. Also, during Oguru and Shell litigation, the plaintiff lawyers traveled to Nigeria to interview witnesses about the oil spill data, but found it very difficult due to pressure and intimidation by the company. Many of these experts worked for Shell and they were unable and unwilling to testify against the company. Also, the prevention of oil spill. There are several claims that the oil spill have been caused by sabotage and theft. These companies are always using this as a defense because in the Nigerian law, oil spill caused by sabotage and theft, the company will not be held liable for it, and also the victims will not be compensated for the oil spill. Also, Shell also frequently dispute information related to the cause of oil spill, the volume of the oil spill, and the area affected by the oil spill. For example, in Bodo and Shell litigation, Shell only accepted to pay compensation and cleanup of the oil spill when evidence emerged in court during litigation that they were warned of the faulty oil pipeline. They were warned about their faulty pipeline but failed to take action. This is a reactive approach. So let us explain how the multinational oil company with a proactive approach improve human rights and environmental protection. In the 2006, the Nigerian government commissioned the United Nations Environmental Programme to conduct environmental assessment in Ogoniland. Shell was proactive in its involvement as they were part of the independent assessment and also accepted to fund the assessment and provide data as requested. So Shell also agreed in advance to accept the findings and the recommendations of the report. After the report was concluded, Shell then established an independent committee to review its practices on remediation of oil spill, and also since then there have been cleanup and restoration of contaminated sites in Ogoniland. And the findings of the report have been referenced in several human rights litigation. So in the presentation, the impact of the multinational oil companies' level of engagement with their human rights obligation during litigation arising from the Niger Delta has been discussed. A proactive level of engagement is recommended to improve human rights and the environment in the Niger Delta. These are my list of cases and references. I'll be happy to answer any questions. Thank you.